now in session. You may be seated.
Thank you, Madam Clerk. I want to welcome you to the Tennessee Court of Appeals. The panel this afternoon will be Judge Friesen to my right, Judge Davis to my left, and myself, Judge McMurtrie. Are there any preliminary matters, Madam Clerk?
No, sir, Your Honor.
Then will you please call the first case?
Yes, sir. John S. McMurtrie et al. Versus Ransford, Sarfo et al.
By way of an initial question, is it 15 minutes per side or 15 minutes per party per side?
15 minutes per side.
Okay, thank you, Your Honor. Then, I would take about 10.
Okay.
Mr. Costner will take 5 unless he wants to reserve a minute or two for rebuttal.
Okay. Let's see. You're representing.
I represent the Daily Times.
Okay.
And Adams Publishing.
Okay. And this is.
This is Mr. Collins, who represents the plaintiff, and that's Mr. McMurtrie sitting at his right.
Okay. Then you're going to do the initial opening. You're going to take 5 minutes. How many?
10.
10. And then as rebuttal, the other 5 will go.
I'll set mine for rebuttal. Very good.
Okay, then good. Then. Okay, you do your 10, then we'll do the rebuttal after. Okay. Then you may prepare to proceed.
Ready to go? Okay. May it please the court, my name is Rick Hollow. I represent Adams Media and the Daily Times. This is a case filed pursuant to, or the motion actually that brings us here is filed pursuant to the Public Participation Act, which I'm sure the court is totally familiar with since it's been around for a while and has been actively litigated. In this situation, we're really fortunate in that there are no factual disputes, virtually no factual disputes. I mean, it's almost like a situation where you're trying it on stipulated facts, because the scenario which gave rise to the litigation, everybody agrees occurred. Ransford Sarfo, a young gentleman, African-American gentleman from Maryland, who was an alumnus of Maryville College, went to the Maryville College campus on July the 9th, 2021, and was looking for his senior residence hall, which is a place called Carnegie Hall. It was raining. It was a bad day. He was driving a rental car. It was a Prius. He didn't quite know how to operate the Prius. He stopped to take a photograph of the dormitory, engaged the emergency flashers on his vehicle. At the same time, Mr. McMurtrie, who at that time was the director of safety and security for Maryville College, he's a former FBI agent, former highway patrolman, lifelong law enforcement officer, approached the Sarfo vehicle from the rear, saw it stationary, the lights on, raining. An arm came out motioning him around. He drove up alongside the Sarfo vehicle. I'll just get to the very basics of it. Honked his horn a few times. Mr. Sarfo rolled down his driver's side window. Mr. McMurtrie rolled down his passenger side window. And there was an exchange that took place between the two gentlemen. It was initiated by Mr. McMurtrie, who allegedly said something like, "What are you doing on my driveway?" Or "Why are you in my driveway?" Anyway, we've agreed to whatever it is he said. It's in the pleadings. Mr. Sarfo felt that that was not an appropriate thing to say, since he was a person of color, and he felt as if Mr. McMurtrie was not being appropriate in his demeanor and attitude toward him. And so one thing led to another, resulting in Mr. Sarfo sending an email to the president of Maryville College and to other members of the college staff protesting, or not actually protesting, but just objecting to the way he was treated. He felt as if he was disrespected. He was an alumnus. He had graduated from that school. He was the first African American to do so. And he was being told by somebody who said, "What are you doing in my driveway or on my campus?" Which, of course, it was supposed to be in jest, according to the plaintiff's viewpoint. But if you think about it, what does that imply? It implies I have control of this, and I have the authority to do what I'm going to do, and I'm asking you, what in the world are you doing here without my permission? I mean, that's really what it implies, at least if I read it, that's what it implies. Anyway, the bottom line was that there was an investigation. There were meetings with Mr. McMurtrie and the staff of the college on June the 26th and June the 29th, or July 26th and July 29th, I'm sorry. The bottom line was that Mr. McMurtrie was terminated with his position. Now, the Maryville Times ran two stories. The first story was on August the 8th, which was after the July 29th, 26th, and 29th meetings, and the story focused on a statement made by Maryville College president saying that they had to be more inclusive. They wanted to have a welcoming, but basically the statement was, we made a mistake, we should have done better, we will do better, and we're sorry that Mr. Sarfo was uncomfortable as a result. That's basically what the gist of it was. Mr. McMurtrie was ordered to do some remedial training. He did. Maryville College terminated his position. The Daily Times reported the story when the president of Maryville College made the statement about, we could do better, we have to do better, that type of thing, and it's all in the record. And then later, when Mr. McMurtrie was terminated, the Daily Times did a story that he had been terminated, and they identified, for the first time, they identified him. It is the position of the plaintiff, apparently, that we defamed Mr. McMurtrie because, number one, he was a private person on a private campus and talking to another private person, and therefore there was no public issue involved, and therefore there was no constitutional protection for the comments that the two men made to each other, for the speech. That seems to be the position that they take in their brief. Of course, we disagree with that vigorously. Maryville College is a private institution, but it's private because it was founded as a private institution. It has private funding, but it takes public funds. It holds itself out as accepting students from a wide variety of places, and has many grants and scholarships that are available. And even though it is a, quote, private institution, it is very much public in that it holds itself out to the public as providing an education if you can qualify and pay the tuition, and it's an excellent institution by all counts. They have a security system, a security force. I think it's composed of 5 or 6 people, of which Mr. McMurtrie was the head. According to Mr. McMurtrie's affidavits or declaration, the security force has no authority. They're not sworn law officers, although the Maryville College booklet says that they are state licensed law enforcement officers, but there's a difference, I'm assuming, between licensure and post certification, which you have to have in order to be sworn. He makes much of the statement that they're not sworn law officers and that they don't have the authority basically to do anything except write parking tickets, which can't be enforced in court. Now, please, you have a security detail, and the college says, if you have a problem, call security first. They'll be your first point of contact. But they argue that this is they're basically a bunch of Barney Fifes, and they don't have any authority to do anything except issue worthless parking tickets. But yet, Mr. McMurtrie, when he encountered Mr. Sarfo on the morning of their conversation. He said, "What are you doing on my campus? What are you doing on my street?" Does that sound like somebody who knew that he didn't have authority to do anything except write parking tickets? And, would that convey that information to the person to whom he's addressed in that circumstance? So, and I know that this court has, you have adopted and utilized the functional equivalency test many times. Functional equivalency test is widely used throughout litigation in the areas of attorney-client privilege, in criminal situations where you have an interrogation by someone who doesn't Mirandize, and yet they are the functional equivalent of the one whose job it is to interrogate and should Mirandize. And here, even if Mr. McMurtrie was, as he said, a powerless individual, he certainly was the functional equivalent in the eyes of Mr. Sarfo or anybody else out there. He was the functional equivalent of a law enforcement officer to which the Times Actual Malice standard applies by the rules of this, by a decision of this court. Even if he wasn't, you still have a situation where, oh my goodness, you still have a situation where he was involved in a matter of public or general concern. And that's another one of the areas that the Public Participation Act allows to trigger its applicability. I mean, think about this. The Rodney King killing was 2 years before this event. The officer who killed Mr. King had been sentenced after a jury trial 1 month before Mr. Sarfo encountered Mr. McMurtrie. That's a matter of fact.
You mean George Floyd.
Pardon me? Floyd.
Not
Floyd.
Rodney King.
Floyd. I'm sorry. I get Rodney King and George Floyd. I do that. I don't know why I do that. One's in L.A. and the other's not. So I apologize for that. Not an attempt. But you look at the wave of violence that swept this country, and you look at, fortunately in Tennessee, we escaped it. But you look at this situation and you have to ask yourself, how would I, as a young man of color, feel if I were approached by a white person in a position of authority who tells me, "What are you doing on my campus?"
But is that the test?
Pardon me?
Is that the test?
No, that's not the test. But the perception, Mr. Sarfo made certain comments in an email, but the perception of the person who makes those comments is critical to whether or not they become privileged by virtue of being an expression of opinion. And that's where that is key, Your Honor. That's where that's key, the perception that he had.
Okay, thank you. We have your position, and your time is expired.
I'm just too gabby. I'm sorry. I apologize,
That's
Your
no
Honor.
problem. Yes.
Good afternoon. May it please the court, Richard Collins on behalf of John McMurtrie, who's here with me today. I think it's important to point out on the front end what we're here, the unique posture of this case at this time. The Tennessee Public Participation Act is an anti-SLAPP statute. So in a defamation case, the defendant can come in and say, the actual malice standard applies, that this is protected speech that the plaintiff is claiming was defamatory. And the statute essentially requires the trial court to conduct that analysis early on. And it's a very simple analysis. Well, that's probably not the best way to describe it, but it's a single question. Is this First Amendment protected speech or conduct? Is that what's at issue in the complaint or not? And if it is, if the trial court decides that it is protected speech, the burden shifts to the plaintiff to establish the elements of defamation, importantly, defamation under the actual malice standard of New York Times versus Sullivan. So not all defamation gets the same treatment. If it's ordinary defamation, which is exactly what we say it is, the Tennessee Public Participation Act simply doesn't apply. It doesn't shift the burden. It doesn't mean anything. But the effect of it is it requires the court to make that determination early on, which is this protected speech or not? And if it is, the upshot of that is actual malice standard of New York Times versus Solomon applies. And as the court knows, it's a very difficult standard to meet because it requires actual malice, requires that the defendant knew the statement to be false or was so reckless with it that they recklessly disregarded the truth. So I think it's important, and of course, the statute also grants an immediate right of appeal. So that's why we're here. So turning to the case and what was decided below. Of course, John McMurtrie has a long law enforcement career. He was with the Highway Patrol in Indiana for many years, and then he took a job as a special agent with the FBI and was there decades. Around 2016, he retired. The FBI forces agents out, at an early retirement, and many, like Mr. McMurtrie, seek private sector employment, and he did. And he accepted the job at Maryville College as the Director of Safety and Security. The encounter with Sarfo, yes, we mostly agree on the facts, but essentially it's a rainy day. Mr. Sarfo is visiting the campus. It's dark outside. He's on Circle Drive and he parks his car in the middle of the street on a sharp turn. And Mr. McMurtrie is doing his rounds. He sees this vehicle, what's going on here. The vehicle, Mr. Sarfo eventually waves him on. Mr. McMurtrie pulls parallel to him. At that point, this is in the record and in the complaint, which is what matters, Sarfo essentially ignores him, sees him, but ignores him. He beeps his horn, and at this point, Sarfo rolls his window down, and McMurtrie does the same. And he does say, "What are you doing in my driveway?" Now, that statement is, frankly, it's an old law enforcement statement. You pull from his highway patrol days, but it doesn't really matter because it's not an offensive statement in and of itself, but even that is irrelevant. Sarfo becomes noticeably agitated. He says he's an alumnus, that he's entitled to be there, that he's merely taking pictures of his old dormitory, and Mr. McMurtrie says, "That's fine, that's well and good, but move your car to a parking space." And he points over to the many parking spaces right there in front of Carnegie Hall where Mr. Sarfo could park safely without creating a hazard. The exchange goes on, maybe a few more words. Mr. McMurtrie identifies himself as the Director of Safety and Security, and Mr. Sarfo, or Mr. McMurtrie rather, leaves first, drives away, and he can see finally that Mr. Sarfo in his rearview mirror is doing the same, that he's moving his car out of the way. In that exchange, however, Mr. Sarfo says to Mr. McMurtrie, "You're going to hear about this." So he's essentially threatening that he's agitated. He says he's entitled to be there. He's clearly offended. And he tells Mr. McMurtrie, "You're going to hear about this." Well, sure enough, the next day, Mr. Sarfo sends an email to administrators. This email is actually was not in the record before the trial court, as I understand it, but it now is part of an appendix because the defendants filed it. But in the email, which was dated July 10, he complains about the encounter, and he essentially links it, and this is now in the briefs, links the encounter to his time there as a black student, where he felt that he wasn't always welcome, and he says that he felt he wasn't welcome. And then he goes on to make some actual factual misstatements, such as, "He told me to leave," he being McMurtrie. "He insisted that I leave." These are factual statements that Mr. Sarfo misrepresented to the school. That wasn't good enough, though, for Mr. Sarfo. Instead, he involved the Daily Times. And yes, I think that the climate of the Black Lives Matter movement at the time was a factor in this case, because the Daily Times was eager to seize on it and to make something out of nothing. And so then they run a report, an article on August 7. Corker, the president, says Maryville College must do better on inclusivity. It recounts Sarfo's version of the events with Mr. McMurtrie. And then in this article, Mr. Sarfo links his experience with Mr. McMurtrie to the racism, the systemic racism that he says that he experienced at Maryville College, describing bananas at his door, seeing a Confederate battle flag at his residence hall, seeing swastikas painted on parking lots, and being the only black student on campus. So the implication that Mr. McMurtrie, this former FBI agent who his career is impeccable, he's above reproach, is now, in the eyes of the world, a racial profiler. Someone who targeted Mr. Sarfo merely because of the color of his skin, rather than the fact that he was parked in an unsafe location in the dark during the rain. Well, even that wasn't good enough. The school had decided, well, we're going to, the school determined that Mr. McMurtrie hadn't done anything wrong. There was no element of racial profiling or harassment involved. Race was not a factor. And in fact, McMurtrie wouldn't have even known Mr. Sarfo's race when he decided to pull aside up beside him and ask him to get his car out of the roadway. But none of that was good enough for Mr. Sarfo. He kept pushing. The alumnus, as he even says in his email, he wanted a pound of flesh. He wanted Mr. McMurtrie's job. He wanted to turn this into something it most certainly was not. And Maryville College caved to the demands. And they terminated Mr. McMurtrie's employment over this incident while recognizing that none of it was really true. At that point, the Daily Times runs another article where they regurgitate the same defamatory story. This time, Mr. McMurtrie's headshot is right there in the article. And again, the article links Sarfo's version of the event to the historic racism that he felt as a student there. The implication is clear that what Sarfo and the Daily Times are reporting is that Mr. McMurtrie is a racist, which is untrue. And that's the clear implication of these stories and Sarfo's comments. And of course, the standard at some point in this case will be, well, would a reasonable person find that defamatory? You might not think the WBR is reasonable, but when they reported on all this, picking up from the Daily Times, they ran a story that says, Maryville College leader apologizes after an alumnus says he was racially profiled. So there's no question about the statements in question in terms of their defamatory nature to Mr. McMurtrie.
Mr.
So,
Collins,
yes.
this lawsuit doesn't involve anything against Maryville College, correct?
That's right. There was we've resolved those issues with Maryville College. Now, so all of that I say, just to give the court a good backdrop, because whether or not these articles were defamatory or not, or opinion or not, that's not before the court. The only thing before the court is whether or not the speech in question was protected First Amendment speech. And so the defendants want to constitutionalize Sarfo's comments and statements and the Daily Times' articles. So how did they do that? Well, there's only a few ways you can do it. You can say that Mr. McMurtrie is a public official. We know he's not a public official. He is not even a sworn law enforcement officer anymore. He is a private security guard working at a private college. He's not a public official. That argument has absolutely no credence to it. You could say he's a public figure for general purposes, that he's just out there, even though he's not a public official, but he's so in the spotlight that, you know, the law is going to treat him under New York Times Sullivan as a public official. Anyway, not so, not here. There's no proof that he was out there in that kind of way in a publicly prominent role of any kind. Never has been. Or the third way is to say, well, he's a private person, but we're going to call him a public figure because he injected himself into a public controversy. No. That's the most attenuated argument that can be made, and it just doesn't stick either, because at the end of the day, Maryville College is a private school. This was private employment. The encounter between Mr. Sarfo and Mr. McMurtrie was purely private. There was no public debate going on about Maryville College. Mr. McMurtry's never represented Maryville College in any kind of public capacity. And so, seeing all these facts, Judge Dugan got it right. Sorry, but we're not going to constitutionalize this encounter, and New York Times does not apply. Motion is denied, and this is a case of ordinary defamation. And so it's really that simple. In briefs, they argue, the Daily Times wishes to present its fair reporting privilege defense. That was not before the trial court. Trial court didn't rule on it, but just to hit it while I can, that privilege says that a news organization does not have to reveal its sources. Well, we already know the source of their story is Sarfo, so the privilege is just completely inapposite to begin with. But to the extent there, there is a privilege in play. The fair report privilege applies to official actions and proceedings, government actions, and the cases make that clear. So there's just no, this case has just no constitutional character to it. And it's that simple. It's a case of ordinary defamation, and Judge Dugan at the trial court level got it right, and I trust that this court will as well. Mr. McMurtrie is not a public official, he's not a public figure, and he's not a public figure for any limited purpose. He didn't inject himself into any kind of public controversy, and it's really that simple. This court should affirm the trial court's judgment in this respect, that the actual malice standard does not apply, that the petition to dismiss under the Public Participation Act was properly denied, and to the extent that this court were to find that Mr. McMurtrie is a public official or public figure, or that this is somehow, and I cannot conceive of how it would do that, but if this is constitutional speech, then the statute also allows limited discovery so that we can at least attempt to make the showing of actual malice. But again, I do not think that is necessary. We ask that this court affirm. Thank you.
Thank you. Yes, sir.
Could I get a 1-minute warning? I'll
1
try to
minute
keep an eye
warning.
on it. Yes, that's it.
Good.
May it please the court, the young man I'm here on his behalf of is Ransford Sarfo. He lives in Maryland with his young son and his wife. I know he's very interested in the outcome of this today.
We're getting your time straightened out. I think he's got 5 minutes.
Okay, I thought he'd asked for an additional minute.
No,
No,
I'm
no.
sorry. I didn't make that clear.
Just a warning. Okay.
Thank you, sir.
Let me try to paint this picture a little more clearly, because I don't think it has been. Mr. Sarfo was in the area, flying down from Washington, D.C. on work, business. He was going to be on the Maryville, in Knoxville. He was going to be on the Maryville College campus briefly. This is in July. This is not in the middle of classes. This isn't when we have students. This isn't faculty You might have a little basketball camp or something, and that's going to be about it. So it's not as if he's blocking a thoroughfare. He pulls up in front of Carnegie Hall where he was a student to get pictures and show them to his wife. It is raining. He's got his flashers on. I don't know if that was mentioned or not, but he had his flashers on. The reason he had them on was because he was having trouble getting his car out of park. Now, Mr. McMurtrie drives up. He looks over at him. Mr. McMurtrie wants him to roll his window down, beeps his horn. He did. He didn't say, "Can I help you?" He said, "What are you doing in my driveway?" Now, let's imagine we are many years back a student at our school that we went to, and that's the greeting you get. "What are you doing in my driveway?" Why would you say that? What is the point of that? What are you trying to be funny or disrespectful? Or it's subject to anybody's opinion and interpretation, isn't it? And then he says, "You need to move." Well, it's in their brief and our brief. There's no question. He says, "I'm having trouble getting my vehicle back in park." Well, you need to move. Any offer of help? No. Following up on the statement, "What are you doing in my driveway?" Certainly, I'm not going to help you. Just move.
Well, all of that's interesting, but what does it ultimately have to do with whether or not Mr. McMurtrie is a public figure?
Well, I was going to address that last.
Well, you have a very small amount of time, Mr. Cosner.
Well, all right, Your Honor. I'm saying that where is the defamation? Where is it?
Well, okay.
That's
when
not the issue.
Right. Well, even if it wasn't the issue, I mean, they called Mr. McMurtrie a racist. They said they racial profiled him.
Who called him that?
The paper. I guess Mr. Sarfo, and
No,
then
no.
reported by the paper. I don't know. The implication is I was racially profiled.
Well, he never used that word. He only said he felt very unwelcome. Dr.
And
Coker,
then
the
he
president of the
referred back
college.
to racial things that had happened to him when he was at school.
Yes.
I mean, I don't know what else you take from that other than he did this to me because I was African American.
Well, he expressed his opinion.
Yeah. But again, how does that make him a public figure?
Well, okay, I'll switch over to
Yeah.
that. I think, as Mr. Hollow has very adequately briefed, it's pretty clear that this was a matter of public concern. And even though he may not have been a sworn law enforcement officer, he put himself in a position to act with authority on this campus. He has authority. What are you doing in my driveway? So I think his authority is very apparent. He's got a security symbol on his vehicle. He states he's the head of security at Maryville College. My client has no idea, of course, if he's a sworn law enforcement officer or not, but he certainly injected himself into a matter of public controversy. Thank you.
I want to thank both sides for your presentation. Your case has now been submitted to this court for resolution. You should receive our opinion and judgment within a reasonable period of time. This time, the attorneys may be excused. Thank you.